So what happens after you file your patent application? I've recently been getting a lot of feedback from the US Patent and Trademark Office on some of the patent applications that I've filed. And what happens next is that the patent office will examine the patent application and they will do what's called a prior art search to see if there's anything else out there that's too close to what your patent application is asking for. And they will, in all likelihood, in about 90% of the cases, they will reject the patent application and they will cite prior art against it. So you file the non-provisional patent application, it sits at the patent office for a long time, and then out of nowhere, you get an office action telling you that your claims are rejected. And then from there, you decide whether you still want to continue trying to get patent protection on your invention. And if the answer is yes, that you still do want to get protection, you still want to seek protection for that invention, then you'll submit arguments and possibly claim amendments to the patent office. And then from there, usually they do allow the case. You just make arguments and make some changes to the claims. And then the patent office will be satisfied that your patent application is suitable for allowance. Recently, in my case, I have a bunch of patent applications that I've filed all at different times, and I'm getting all of the office actions at the same time. So that's been a little interesting. Um, but the other question sometimes people have is why do they do this? If they're just going to give you the patent eventually, why do they need to issue a rejection and not allow the patent application to go to allowance? The reason for that is twofold. Typically, patent attorneys we kind of ask for more than what we know we can get because we don't want to under ask. So we ask for more, and then the patent office says, no, you're asking for too much, make some changes and ask for a little bit less. So that's one of the reasons. The other reason is that it puts a record on file that demonstrates the patent examiner's thinking. When anybody looks at why this patent application issued, they'll be able to see the patent examiner's train of thought. So that's really another reason they want to get something on record regarding the patent examiner's thinking as to why an invention is allowable and patentable. And so for that reason, in most cases, there is a rejection on the initial patent application. So that's something that you can anticipate. If you do file a non-provisional, you probably will get a rejection. There will be additional legal fees. No one knows when this rejection will happen, but when it does, you have an opportunity to make arguments in support of patentability, and from there, you should get a notice of allowance for your patent application. So if this is helpful or you have any other patent related questions, you can book a consultation at the link.